It's an honor for me to present and to moderate the next session for different reasons, but I'm going to give the floor to the panelists because they are the main one. I have prepared an introduction of all of them, but if I read their curriculum, we'll spend the whole session with their curriculum because it's spectacular. So I'm just going to say that we have three panelists. The first one is Louis de Koker. He's professor of law at La Trobe Law School since 2017. He was the founding director of the Center of the Study of Economic Crime. His research focuses on managing the relationship between financial inclusion and anti-money laundering and counter-terrorist financing objectives. He has lots of publications that have been cited by international bodies as the World Bank, the Basel Committee, or the International Labour Organization. And he's going to speak about the regulatory jurisdiction over virtual asset service providers. The second speaker is Professor Michelle Fink. She is a senior research fellow at the Max Planck Institute for Innovation and Competition in Munich. And she's also a visiting professor at Louis University in Rome. Her research interests are artificial intelligence and the digital economy, but nowadays she's focusing on the relationship between digitalization and sustainability. And some of her main publications are sustainability authorities, subnational authorities in the EU law, blockchain regulation and governance in Europe. And she's going to speak about the impact of the Data Governance Act on the decentralization data ecosystems. And the last one, because he is my countryman, but not least, is Jose Manuel Marquez Sevillano. He is the head of the Financial Innovation Division at the Bank of Spain, our central bank, since 2013. In this position, he focuses on studying the main trends transformation of the financial system and define the main implications for the central bank. He has published lots of papers, for instance, one related with financial innovation for a sustainable economy, or Jose digital tokens that are very recent. And he's going to speak about CBDCs and cryptocurrencies, a changing landscape on payment systems. As I have told you, they are the important ones. So we start with Professor Louis de Koker. Thank you, Luis, for participating. The floor is yours.
Thank you so much, Carlos, for that very kind introduction. Ladies and gentlemen, it is a real pleasure and privilege to join you at this discussion. As Carlos pointed out, my interest lies primarily in financial regulation, financial crime, and inclusion. But financial inclusion for the past 15 years have been driven mainly by financial technology. And as a result, I have been privileged to be involved in a host of the discussions that form the framework for this particular presentation. That's going to focus on FATF, the Financial Action Task Force, the global anti-money laundering, counter-terror and counter-proliferation financing standard-setting body, setting standards for all countries around the world in terms of the laws that and regulations that they have to adopt. And I'm going to focus specifically on the virtual asset service provider standards. And I believe most, if not everyone in the room, will be familiar with the terminology because as a body of primarily regulators, they also preferred not to refer to cryptocurrencies, not wishing to credit cryptocurrencies as currency, and therefore they opted for the term virtual asset. And this forms the framework of what I want to address. So we know our 20th century financial regulatory models are based on sovereignty of the state, on national regulations, on national regulators that regulate service providers within borders. And that may not be the case in this room, but the financial regulators that I work with at high levels globally believe that this model will suffice for the future. Now, obviously, crypto asset models challenges the notion that national laws can adequately deal with the new service providers that are emerging. And it also challenges the notion that an intermediation-focused regulatory approach will serve current but also future needs. So what I'm going to discuss essentially addresses the first notion, that national laws can adequately address the new service providers. And while we would normally start with the exciting new, very different features of all of the different products and channels and providers and DAOs, I'm starting from a different perspective, asking the question to this body. So if this is feasible, how well have you been able to capture these new technologies within this model of your standards? And in this investigation, it was a great pleasure to work with Pompeo Casanovas, that we've just heard a little bit earlier, and also Tala Otsal, formerly from the Turkish Central Bank. So essentially jurisdiction, and this is mainly for the non-lawyers, but sometimes it's good to refresh our own legal knowledge. Obviously, we understand the concepts of national jurisdiction that has been with us for a number of centuries, but so has the concept of extraterritorial jurisdiction, especially in the 20th century. The idea that your laws can also apply outside of your borders because of mainly three key reasons. Often nationality, because some countries determine that their laws go wherever their nationals go and they hold them liable. So for instance, if you have child protection laws, the fact that your citizen outside your country does something to their child that may be legal under the laws of where they are, but it's not legal under your laws, will not assist them to escape your jurisdiction. Or territoriality, we see that often in the US context. It doesn't matter whether it's a transaction between two foreign citizens. If it's a dollar-based transaction and in some way it passes through the American financial system, then America has jurisdiction and they can enforce their laws in relation to that transaction. Or universality, especially under UN conventions in relation to international crimes, doesn't matter where they are committed. Now, these are familiar principles. You can claim, if you're a country, extraterritorial jurisdiction on bases like these, but of course, claiming it is much easier than enforcing it. And the challenge regarding both claiming and enforcement is, of course, increased by digitality. So FATF and its concepts of jurisdiction are very much based on 20th century principles and ideas of national jurisdiction. They haven't really been confronted by important questions in this regard, except in relation to shell banks. And that was about nearly 20 years ago. So shell banks were these SIM-file banks that we could register. If you had $35,000, you can actually buy your own bank. You bought a bank license. You may remember, if you traveled in the 1980s, the advertisements in magazines on the planes. You could buy citizenship, you could buy diplomatic status, you could buy a bank. All you bought, of course, was just a file. That protected you if you were a criminal, because if anyone wanted to come looking at your transactions would pass through your own bank, and you would simply say, I don't have that information any longer. So FATF took action and they banned shell banks and transactions with banks. And they defined them as banks that operate without a presence, a physical presence in the country where they are registered. And that meant, kind of in terms of physical presence, the key question for FATF was, is there a meaningful mind and management of that bank in the country that gives the license? And they also said, and they still say in these standards, that excludes simply a local agent or low-level staff that is present in the jurisdiction. That does not constitute physical presence. So interestingly enough, that did feature when they started to think about virtual asset service provider standards, but not extensively. So in terms of the standards that were adopted in Recommendation 15 in 2018, essentially they required countries to ensure that VASPs are regulated for AML/CFT purposes by being licensed or registered and subject to effective systems for monitoring, so supervision, and ensuring compliance, supervision, and law enforcement with the relevant measures. Now, this idea of mind and management in relation to shell banks is something that they carried over into the VASP standards. And this actually derives from English law, a 1907 case, where Lord Lawburn said that the real business of a company is carried on where its central management and control actually abide. So where the central management and control actually is. And in 1995, this was unpacked in an important case. And a number of key principles were formulated that I think even then were somewhat quaint and outdated. For instance, saying the company is resident where the directors meet and transact their business and exercise their powers, as if that all happens in one kind of physical space. And they recognize that it may happen in more than one place, but then only said that, well, then the company is where the central management and control actually abides, as if that is necessarily in one place. And essentially said this is a question of fact, and it's a fact not determined by the company's documents and what it should do, but what it is actually doing. Now, these tests for minded management or effective place of management features actually in the laws of many countries, especially the tax laws, despite them being well out of step with modern practices. So what did FATF require? It required jurisdictions to license VASPs in the countries where they are created. Now, creation there, they explained, in relation to a legal person means where a company is incorporated or the trust is set up. While I'm let me perhaps quickly run through these and then return to them. If the VASP is a natural person, a human, they said, well, then look at where the place of business is located, which depends on, where the primary location where the business is performed, where the books and records are kept. And if you think about this and you think about modern business and virtual businesses, don't laugh out too loud, but this was actually incorporated into binding global standards in 2018, where their books and records are kept, where the natural person resides, where they actually live, or where they are resident, or potentially where the server of the business may be, as if it can't quickly be shifted from one country to another. And then they said, these are the binding rules, but you may also consider extending or reach to VASP that offer products or services to people in your jurisdiction. And earlier this year, in a public consultation, they aired the possibility that if you've got employees or management located in your jurisdiction, even though they don't offer products, you may also consider regulating them. The message generally was rather go broader to try and prevent unregulated VASPs, even though they may end up being regulated by 3, 4, 5, 10 different countries. Now, if we look at these principles, they are very kind of mid-20th century. And the notion that you can regulate a VASP, which is a business, by looking at the creation of the company that may be conducting the business, kind of conflates the company, the legal person, and the business that it conducts. And that in corporate law is a bit of a nonsense. And a business can be very loose from a company. A business can be shared among different companies. It may be shared in a consortium of legal persons and companies. Control may shift. How on earth can we end up with basic mistakes like this built into the international financial regulatory framework if there's a serious possibility of national jurisdiction actually working? And then a lot of attention is being given to jurisdiction, but the key issue is, once you've regulated something outside of your jurisdiction, can you actually effectively supervise them? And FATF did consider that. At least in its guidance, it mentioned this idea of perhaps you should consider thinking about establishing a supervisory hold over something not in your jurisdiction, require them to have a resident executive directive, for instance, or substantive management presence, or specific financial requirements, whatever that may be, pay some money into an account of the supervisor. Ideas, but none of that actually provides a really strong supervisory hold. You know, it's a full guy or girl that would be set up as the director in your jurisdiction, while the real business can be continued elsewhere. And there may not be too much of a concern. We saw that with compliance officers in the 1990s. They knew that if anything goes wrong, they would need to go to prison, and for that they are amply rewarded. To carry that risk, they carry the risk for a year, and then you appoint another person, and so the carousel turns on its own axle. So if we look at a number of countries, Canada is an example of a country that has extended its reach outside of jurisdiction, and I'll quickly whip through these to come to the end, Carlos. I'm keeping my eye on time. But no indication of supervisory hold in the Canadian regulations. Singapore does require their regulated VASPs, called DPTs, to hold a payment institution license, and a licensee must have a permanent place of business or a registered office in Singapore. That's good, but all it requires is at least one person to be present at specified times. And then they require the books also to be available. Now, that's good from a supervisory perspective, but does one person, without saying at which seniority level they need to be, really provide them with a hold if it comes to enforcement? Japan has its own concepts of VASP, and I'm not going to drag you through that, but what they do require is, if you are a VASP regulated by a different country and you wish to operate in Japan, you must have a local office in Japan, and the representative of that office must have Japanese residency. All right, that sounds like a little bit more of a supervisory hold. But if you are not regulated and you are foreign, so you're not regulated under the laws of another country and you're foreign, then you must set up a stock company in Japan and register as a VASP equivalent in Japan. The UK regulates VASPs, but only those who carry on business in the UK, not those who carry on business outside the UK. And the limits of that approach has been illustrated by the FCA statement in relation to Binance. a couple of weeks ago, where they warned that Binance is not regulated under UK law. It is now the second largest digital currency exchange in the world. It's not regulated in the UK. It's not registered. It's not authorized to do business. Well, the problem is that does not prevent its citizens from continuing to do business on the Binance platform. All it means is that none of the Binance subsidiaries in the UK may do such business or advertise related business, but those outside of the reach of the UK law, they may continue and citizens may continue to use them. And then lastly, Australia and the USA both apply extraterritorial jurisdiction. Australia doesn't have much of a supervisory hold, neither has the US. But the difference is the US is in a different position. We've seen that in the past 20 years. They use their economic power and the power that they exert on countries, normally Europe and the UK, that are sympathetic to the US to help them enforce their extraterritorial laws. So they've actually been able to enforce in relation to Telegram and TUN and also in relation to BTC, even though they were registered and operated totally outside, for most, outside of the US. But what Telegram did was, unfortunately, they used part of the federal communication system, and that provided the US with extraterritorial jurisdiction, and they had enough funds there, the same with BTC, to enable them to enforce the law. Now, that works well for the US. Problem is, that's not something that would work for most other countries, and especially the smaller jurisdictions, the Maltas, the Estonias, or the El Salvadors, for that matter. So, in conclusion, we are thinking about regulation and the exciting questions about the products of the future. The regulators themselves are still clinging to 20th century models. Some FATF members have been more pragmatic than others. For instance, Japan. The problem at the moment is it can actually undermine integrity, because if you're an unscrupulous foreign VASP, you can now apply for a license in Australia and be granted it on the basis that you may want to offer your products to Australians. That provides you with a legitimacy of an Australian license that you can then use to commit investment fraud. And the chances of Australia actually getting hold of you or preventing that is going to be fairly slim. It's going to take time, and most fraudsters are playing for time in the market. Now, the interesting thing is, FATF shouldn't need to struggle with all of these on their own, because the tax authorities are also struggling with these issues. We've seen the latest G7 approach. They want to tap the profitable fintech companies in this space, and yet we don't see a joined up approach. Now, obviously, regulation is only the first step. As I've been kind of making the point throughout, the real test lies in supervising, for which you need visibility, and ensuring compliance, and then actual enforcement, where you need to enforce against a business that may not be interested in kind of being imposed upon by the regulator. That's an issue, and that issue has not yet been addressed. So we know the future lies elsewhere, not in national regulatory models. It may lie in co-regulation, in meta-regulation, in compliance by design, compliance through design, the exciting kind of ideas that Monica has been exploring, Pompeo is exploring, many others in this discussion are looking at. But for that, we also need to convince the national regulators that they need to start thinking differently. And that is the main reason why my paper has been so differently focused, to try and build the argument that what they've been trying to date, they don't need to wait 5 years to see it's not working. We can actually start doing some analysis on it now to convince them that perhaps they need to start embracing the exciting opportunities of the future. Carlos, thank you so much for your patience.
Thanks to you. It's a pleasure to hear you. And thank you very much to stick to the time.